We've gone live. You can please, if you just introduce yourself a little bit. Everyone knows you, but I'm just saying.
Thank you for the absolute honor of this opportunity to present across the world and be connected on a topic that I am absolutely passionate about. My name is Sarah Blake, and I'm a conflict strategist. And what that means is, yes, I'm a mediator, but I'm also helping people have the difficult conversations and make good decisions in their everyday lives, in their business and commercial lives. I am based here in Australia, in Perth. It feels like a long way away from you all, but I know that thanks to Zoom, we are connected. And this sense that as a profession, I think it's wonderful that we are just connecting more and more. Before I get into my presentation and bring up my slides, I just wanted to say, in my country, part of our traditions is around acknowledging the traditional owners of the land that we are on. So I want to take a moment to really set the tone today and pay my respects to the traditional custodians of the land that I am on, the Whadjuk Budjar people on Noongar land. And pay my respect to their elders, past and present, and acknowledge their wisdom and continuing connection to country and that contribution that they make to society. The photos that I use throughout the presentation today, some of them they're all photos I've taken, but some of them are private, but I have permission to use them by the Aboriginal communities that I've liaised with. So I just ask that you respect that and the privilege, I guess, we have of being able to share and access those photos. I'm going to pull up my presentation so that we can start going through that. And then we can kick things off. Screen sharing has failed. Do I need to, can we try that again? I'll just see if it pops up again.
That's okay.
How's that? I think that's working now. Can I get a thumbs up, Vikram, if you can see that for me?
Yes, Sarabhi.
Brilliant.
Thumbs up,
Thank
voice,
you.
everything.
So today the discussion is mediation culture and traditions, conflict and mediation, and working across cultures in Australia. So I'm going to bring, I guess, some of my experiences from Australian perspective and share some of those stories with you. I love this topic, and the more that I do my work and the more that I reach out into the international space, that I realize how important it is that not just to be conflict competent, but to be culturally competent practitioners. And I think it's a skill that we often undervalue because we're so used to, I'm a non-lawyer practitioner, but for many people coming from a legal background, it's very easy to focus on the process and the steps of mediation. And we forget to bring people into the room. So today I'm going to do a little bit of that. Bring people back into the room. If you've got questions as we go along, I think they might pop up on the chat box, which I'll check at the end. And I will absolutely leave time for questions at the end because your questions challenge me and help me learn and grow as well. So what are we talking about today? We're going to be talking about mediation in Australia. We're going to touch on and really delve into what does this word culture mean in an Australian context. And then I've got a few little tips to share with you and we'll finish with a Q&A. So hopefully I could probably talk about this topic all day and I'll try to be very disciplined and focused in what I do. I'm also really conscious that whether you're watching live, whether you're watching playback, or whether you're here right now, that you're also bringing a wealth of knowledge and experience to the table. And these are the conversations that I think are really enriching our profession. And I want to encourage all of you to make those times for these conversations, not just here now, but when you leave the room, when you go and talk with your colleagues. So how can you keep this learning growing? So I'm going to kick off with a little bit of my story as a practitioner, because I think it's useful in how it frames my own views of mediation in Australia. I am a second generation practitioner. So my father is a barrister and was one of the first mediators to really kick off the profession in Australia. Him and a number of other lawyers got together and formed what was known at the time as LEADER. Leaders engage in alternative dispute resolution. So I guess, very privileged to have grown up with the language of dispute resolution, of mediation, of group decision-making and discernment. And that has really shaped how I practice mediation. And I guess, to be perfectly honest, I didn't think that I would end up following in my father's footsteps. And I have. And I absolutely am passionate about this. And I think that that helps me expand my vision and my view of what mediation can be, and more importantly, how we can make sure that it services the people in conflict. So my story as a practitioner began in very young days when I was having to talk the language of mediation. As a mediator, I was trained way back in 1996. So I have been in the profession for over 25 years now. I started my mediation career in the space of neighbourhood disputes. So in Australia, we had organisations that were providing a conduit between community small-scale conflicts and trying to get them to resolve them before they ended up in court. There are issues around barking dogs, noisy neighbours, fences, pools, all of those sort of minor conflicts from the outside. But when you're in the middle of them, you understand that they mean a lot and they impact people's lives. So this was such a rich learning ground because I had to not just navigate conflict generally, but values-based conflict, personal, real, meaningful conflict. And that's how I started. That's how I started my career. My work has taken me across Australia and in the Pacific and internationally. A lot of my work is done in remote Aboriginal communities. I've been absolutely privileged to walk in this cross-cultural space, and I have learnt so much about myself personally, not just as a professional mediator. So some of my photos are up here of me out bush, of me working with a lot of high conflict party complex cases. And I think it's shaped how I view culture, and it shaped how I view mediation's place in society. Feel free to ask me questions about this because I always get asked them at the end of the session. So that's a little bit about me. I now do a lot of, like I said, high conflict work, which is commercial boardrooms, organisations and remote community work. I balance the two. And in part so that I don't get burnt out. For those of you that do a lot of community work, it has a cost. We walk in the conflict space and we have to nurture and care for ourselves. So I have that walking in two worlds, essentially. So mediation in Australia, how are cultures and traditions being valued in process design and in practice? It's a really great question, and I'm so grateful that they are engaging in this. The history of mediation in Australia is coming on probably close to 40, 50 plus years now. And I think that it talks to the Western concept of mediation is really integrated into our judicial system. And so I think that that's really enabled us as a country to create a depth to our practice. What is not so deep in our practice is how traditional and diverse cultures are embraced into that Western system of dispute resolution. And that's the stuff I'm really interested in. So here in Australia, back in 2008, we established the National Mediation Standards, or the National Mediation Accreditation System. And it's useful for us to just touch on that because that's the framework which holds us accountable. It provides the standards which we are held to and that we are providing to others. And it also gives our clients confidence that things like professional development, insurance, codes of conduct are all a part of that standardization process. Interestingly, though, it's a voluntary system. So it does create tension in our profession around who can call themselves a mediator and how are they mediating? And are they mediating to national standards, or is it something else that they're doing? And I think that as a nation, we are probably grappling with some of these questions, certainly from a intersection of how particularly the ex-judges and lawyers are conducting mediations more determinative in process, as opposed to those that are more of a purist mediator where the focus is on process. So in Australia, I think our next evolution is around how we address those challenges. How do we define what mediation is here in Australia? And I think that, in every country, and even with the Singapore Convention, there's still nuances to what we call mediation. So here in Australia, it is that mediation is a process that promotes the self-determination of participants, and in which participants, with the support or help of the mediator, communicate with each other, exchange information, and seek understanding. They identify, clarify, and explore interests, issues, and needs, consider alternatives, generate, evaluate options, negotiate with each other, and reach and make their own decisions. For most of you, this will sound really familiar. Pretty much aligned with the Harvard model of mediation, the double triangles, however you frame it. I think these are some really consistent things. Nevertheless, there is confusion around and liberties taken around how much the mediator plays a role in, for instance, managing power dynamics, how much the mediator plays a role in helping parties evaluate their options, the role of the mediator in helping to clarify the issues and bringing expertise to the table. There'll be differences in approaches, whether it's from for instance, a family-based mediation system, or whether it's been done in a commercial space. So all of these things, there's slight differences in how it's played out, whether we do caucus or not caucus. So there's genuine flexibility within our national standard system that allows difference to be embraced. And you'll understand why that's so important as we continue on. A little bit more about the Australian context in terms of the mediation landscape here. So, as I said, because of the long history of mediation in Australia, the courts have really embraced this. Certainly in Western Australia, the Supreme Court conducts a very, very high percentage of their cases start in mediation. So very few are getting through to the court process, and they're resolved early, either through mediation or a negotiated agreement in that early preparation stage. So this court annexed mediation is a very common occurrence. Mediation itself is also built into legislation. It's built into the family law and around divorcing and separating couples. Fair Work Australia, the Discrimination Commission, a whole pile of tribunals require participants to engage in mediation. Essentially, if you want to take a case to court, you have to demonstrate that you've actually attempted to resolve the issue through a negotiated process, whether that's mediation or something else. Generally, lawyers are embracing mediation and recognising that this is the first port of call. So I think that is a wonderful recognition of the role of mediation in Australia. We've certainly seen some very high-profile cases recently resolved through mediation that have hit the media. And I think that that's an interesting thing to observe, that we talk about culture and culture acceptance of dispute resolution. There seems to be this normalisation and embracing of that mediation is an acceptable approach and a thing to do. So it's becoming part of our cultural responses more widely. From a workplace, commercial, family, and community perspective, there's mediations happening everywhere. And not just mediations, mediator skills are being recognised as essential assets for leaders, for HR departments, and a recognition that mediation can contribute to conflict management practices. So starting to recognise that mediation itself is just one aspect of how we deal with conflict problems. So it's a wonderful landscape to be working within. I would have to I guess, be brutally honest too and say that it's very difficult for new mediators who are coming up through the profession to find full-time employment as a mediator. And even mediators that have been around a long time, it's very difficult to only work as a mediator unless you're, and certainly for lawyers, they're supplementing the mediation work. There was a report that came out of New Zealand which highlighted that the percentage of mediation work was going to maybe 2 or 3 senior mediators, and that was it. Everybody else was trying to compete for the scraps left over. So I think that we also need to recognise that as we create sustainability for our industry, that there is this disconnect between those who are really experienced and those who are coming up, and how we make space for each other in that. So I think that's a brief, I guess, introduction to mediation in Australia. It's certainly an exciting time, but there are some identity challenges for us as a profession here around what is mediation, how is it distinct from determinative processes when you've got determinative legal practitioners coming in with their frame of reference, and how do we empower parties who are looking for something beyond a tick box process. So we're going to end up our discussion around that place, and I'm looking forward to hearing your views on that. So we step our toes into this question of culture. What is culture? How does it impact? Does it even matter? This is something that I'm really interested in as a practitioner. And culture being the norms, the ideas, the behaviours, the way that we act and make decisions that are based on our societal experiences. It impacts our laws, our religions, our values, and our stories. Culture has such a significant impact on how we make our decisions. And we forget that because we get so caught up in living and experiencing that. And it's not until we have to work in an environment across cultures, whether that's cultural diversity from Indigenous and non-Indigenous, or perhaps it's commercial versus a not-for-profit cultures. These are all different experiences and values on how we prioritise and make decisions. There's some really interesting developments, particularly through the International Mediation Institute around their cultural competencies. And they talk about that influence and need for awareness of cultural theory. Foucault talks about this. His influence has been to shape a more discursive understanding of cultural language and the interconnection between power and representation. And I think for dispute resolution practitioners, for mediators, this notion and this interconnection between power and representation is a really important thing for us to wrap our heads around. Because what we're talking about in the negotiation process is how power is used to determine a decision. And representation is so influenced by who is at the table, to what extent do they have authority, and who are they representing, and how far can that agreement be held out and sustained. So I think this definition of culture and culture theory around power and representation is particularly relevant for us as dispute resolution practitioners. So if there's nothing else from my discussion today, it's to really encourage you in all of your work to start to build into your reflective practice an awareness of how culture may be impacting decision-making. So why does this matter? It matters because how do we bring parties together for effective decision-making? That is really, for me, at the heart of what mediation is. It's bringing parties together to help them make effective decisions. Culture matters, but we can bridge the divides for effective negotiations if we build the conversations into our preparation and process design. And I say this because one of the really interesting things that I got out of attending the signing of the Singapore Convention a couple of years ago was this question around, do we need an Asian model of mediation? And it really sparked my interest, and it got me thinking. And it got me thinking, well, this must be a problem. The process and the model must not be working if people are asking that question. And it floored me, because in the work that I do, every stage of my process is negotiated, because if I'm working with Indigenous people here in Australia and they don't feel like the process has meaning for them, then any agreement that is reached is non-sustainable and likely to collapse. So at the beginning, the very beginning of when I'm engaged in some work, there are questions around how can we create a process that enables and empowers you to engage in good decision-making for both parties? And we wrestle with that. And so I'm going to be talking about that challenge, because I think in a increasingly global world, despite being on Zoom, we still need to bring awareness to this issue of culture and how we use it as a mechanism for creating better decision making. I've put this issue here around assumptions and bias. Culture influence on the systems of decision making. Culture influences the system of decision making. And in doing so, it fundamentally asks us as practitioners to question our own assumptions about the operational nature of our model. I'm really curious. So how many of you, when you are stepping into some cross-cultural space, do you make assumptions that everyone knows what mediation is? Do you stop and ask that question? Maybe you're making assumptions around, does everyone understand what confidentiality actually means? Because I can guarantee you, when you're working in the cross-cultural space, there'll be different perceptions of what that means. And that's also true in the commercial space, the cross-cultural commercial space, not just in the community work. And it's very easy for us as practitioners to get caught up and so used to just ploughing ahead and doing what we need to do. And sometimes I think we ourselves need to just stop and pause and ask ourselves, is what I'm bringing to the table contributing to good process? Or are there some assumptions and biases that may also be creating barriers to this process? It requires us to be self-reflective as practitioners. And I'm coming to see lately that I don't think as a profession that we've been particularly good at prioritising and recognising that how we are impacts how others engage with us and with each other. So we also need to be developing this self-reflective capacity and examine how we apply our model. For those of you that are curious about this, jump on and I'll share the link. Vikram, maybe you can share it out later. Harvard have a implicit assumptions and bias test that you can do. And it's a really short 5-minute test. And it's a really good way just to check in and say, hey, where am I thinking? Is what I'm doing helping? Or maybe there's some unconscious bias creeping into my practice that I just need to check in. So I think that these tools are out there. And as a profession, it'll be super exciting if we start to lean in and take advantage of them. I don't know about you, but I know from my experience that conflicts are about so much more than the legal facts. I can't tell you how many times I've heard from lawyers say to me, I can't believe that it was just about this and this. I just thought it was about the money or the interpretation of the law. And I just try not to roll my eyes, to be honest, because I just hear this so often. And the thing is that conflicts happen because of people. Conflicts happen because of our emotions and our challenges and the mess and differences in how we interpret facts and data. So it should be no surprise then that in resolving conflicts, it's going to take more than just a black and white interpretation of the law. Because if it was just about the money, they probably would have already negotiated it themselves. So I think in this cross-cultural particularly, it's about recognizing that we need to make space for complex conversations. We need to make space to draw in the emotions, but not be driven by emotions. We need to make space for the conversations about legal facts because they are important, but we can't let it dominate the negotiation. We need to make space for conversations about what are your interests and what are your needs. We also sometimes need to make space for the impact and the exploration of what happened. But I don't think we need to get stuck in that because remember, a mediation process is about moving forward and looking forward. And if we get stuck in that circle of looking back, here sometimes we talk about too much navel gazing, where it's this, you get stuck in the cycle of looking back. And I think that part of this process is helping people balance these aspects of decision making. How can we gather the right information to make good decisions? So again, I take you back to this notion of landscape. And it's a really nice way to think about culture, the tapestry of who we are, the diverse colours and the weaves and the textures and the feels and the smells and the sights. This sensory explosion of complex diversity. And I think that's a powerful space for us to be working in. But I often say when I'm teaching about culture and mediation, that we can't just focus on the dispute itself. We also need to set the context. This is a space within which the conflict is occurring. And in cross-cultural conflicts, this is particularly important. Here in Australia, I think one of the really interesting trends is the growing recognition that culture plays a big role on how people engage in effective dispute resolution or not. And in some ways, it's really emerged out of native title. So the negotiations of the traditional First Nations owners of the land and their negotiations with government, with big business around rights to that land. And in the past, the processes have predominantly been Western-led, Western power-based. And what we see is that it's not creating great long-term outcomes. It might reach agreement about a particular aspect, but the conflict itself keeps bubbling and growing. So when we step into a cross-cultural space, be it with the Indigenous people of Australia, the non-Indigenous people, perhaps there's other pockets of cultural diversity. I'm working with people from the Philippines dealing with conflict. I'm working, others like colleagues I know are working with refugees that have come over. There's so much cultural diversity in our society that we here in Australia are really starting to recognise at least that we have work to do. I wouldn't say we have the answers, but at least we're recognising that there is work to do. And there is a thirst within governments, within businesses to find a better way of doing this. I'm going to play you a little video or a little soundbite now. And this is a short exercise that I want to take you through that gives you a taste, a small taste of what it can be like for those living in remote Aboriginal communities. So a lot of my high conflict work, that cross-cultural work, is done with people whose conflict context is very complicated. We've got intergenerational trauma. We've got dispossession of land. We've got significant health issues, shortened lifespans. We've got educational, huge educational gaps, people living in poverty in a first world nation. And then we as Westerners come out and we say, hey, I represent this big mining company or this government agency, and you need to negotiate with us to reach an agreement. Many people in these situations, many Aboriginal people, are being asked to engage in really complex multi-party negotiations. And I don't think that's fair. And I think it makes it very difficult to create good agreements. So as a profession, I think it's useful for us to stop and think about that context and how it impacts people's ability to engage in complex decision-making. This is relevant for me in Australia, but I also think it's relevant across the globe for all people dealing with those in high conflict situations. So if you can just take a moment and make sure your sound is on, I am going to just press play. You can hear the heart beating. When you are living a fairly normal life, you know, you can expect to deal with probably different levels of stress. You know, conflict happens and you do something and you might go through mediation or you might talk to somebody, but you deal with it and you get on with it. So we talk about that in terms of let's go for a run. We go for a run and that heartbeat starts beating. But then after we've had our run, we come back and things start to slow down, right? You recover, you move into that recovery phase and your heartbeat normalizes and it gets slow again. For people living out in remote Aboriginal communities or high conflict spaces, they're living in a situation where that heartbeat, the resting heartbeat, is much faster. And it's much faster because they are dealing with intergenerational trauma. They are dealing with high conflict that happens all the time. They're on edge and they're waiting for that next conflict to occur. They're under pressure, financial health pressures, educational, employment pressures. So this resting heartbeat is much faster. And then it takes a short trigger and suddenly that heartbeat escalates again. So a conflict triggers much easier in these environments. So their heartbeat raises and then it escalates and then they come down, they deal with that conflict, but it doesn't come back to the same resting beat that yours might. Their resting heartbeat, again, remember, is much faster, which again means they don't get that deep level of recovery. It also means that their conflict trigger, those things that trigger off the cycle of conflict, are much shorter. So again, it's not going to take much to trigger that next cycle of conflict because they're already halfway there. So you're dealing in an environment where heartbeats are up. People are looking for a reaction only because they're in survival mode. And we know when we're in survival mode, we don't necessarily make good decisions. We can't take on good information because we are in survival mode. So in high conflict situations, particularly in this cross-cultural environment, as practitioners, we need to be alert for how people are and how their own conflict context is impacting their ability to engage with a process, to engage with the other party, and to take on more information and make good decisions. This is complex business, working in the cross-cultural space. So you've heard me talk about high conflict. I just want to flesh that out a little bit for you, because I think from my perspective, we hear about high conflict being high conflict personalities, but I want to broaden that out to high conflict situations. High conflict conflicts are disputes that have been live and sustained over a period of time. And that period of time is from 6 months to 5 years to intergenerational. These are deep-seated challenges. They will often be multi-party, but not always. Parties tend to react with high emotion. They tend to be highly positional and demonstrate difficult negotiation behaviours. We often see in high conflict situations a factionalism forming, that people won't move out of those factions. In the cross-cultural space, it might be Indigenous and non-Indigenous people, or it might be in a development issue, and you've got your green supporters, people that love the environment, and your developers who want to build a high-rise building. There's some cultural challenges here. These cultural challenges is around the values and the prioritizations that they use when they make decisions. In high conflicts, these are often far apart. And it can be really difficult to know how to navigate this space, particularly when we're brought in to try to help them reach an agreement. It can be really challenging. And what I found actually is that sometimes as mediators, we have to recognize the limitations of our own profession. Sometimes these conflicts are so far apart that a resolution isn't possible, but we can manage the dynamics moving forward. So it is about framing what influence do these parties have? How can they move forward? We can't fix all these issues, but perhaps there's elements that we can, and perhaps there's elements that they can find that they can move forward, even recognizing those deep differences. So working in the high conflict space, I think, is so much a part of this cross-cultural space. High conflict is different because of that cycle of conflict I talked about. High conflict is different because the triggers are quite short, and they trigger a very highly emotional reaction in people. And you've probably seen it. They might flare up and you think, hey, what was that about? That was just a little comment. But it touches them deeply in their sense of identity, in their sense of values, and in their sense of purpose. The impact of high conflict is high. So the costs are high, not just financially, but often emotionally, or the unity of the community or the family groups. The costs are often higher. In high conflicts, there's also a limited or diminished capacity to influence change. Often there's quite strong power differences. And one of the parties will probably feel like, hey, I've got no power and I can't influence change. And so what they do instead of exploring that often is bedding down their position. It makes your job harder. They're complex cases, and there's an intensity to working in this cross-cultural space. And the intensity is driven by emotions. So what drives these conflicts? When I take on any of my work, whether it's working with commercial spaces in boards or even in communities, I go through the practice of mapping out the conflict. And I map out the context because it helps me understand who needs to be involved, what are the questions I need to ask, what information do they need, and what might be influencing their own perceptions or decisions in this space. I've just given you a list here of some of the drivers of some of the cross-cultural work that I deal with. And that can include power, politics, and personalities, governance systems, and clashes between systems of law. So traditional law versus Western law. Money and resources, always an issue. Information or a lack of information. Perhaps it's a lack of access to lawyers. values and culture, environmental, social justice issues, developmental and infrastructure issues. There's historical stories, there's historical experiences that taint or bring bias to decision-making. Relationships, partnerships, education, employment. I mean, I could go on. The list is long. But these are the things that you start to see influence on our culture and the way that we make decisions. So how do we bridge this cross-cultural space? We do know the Global Pound Conference report from North America, supported by IMI, made the findings were very clear that parties seek more control over the process. They may want to be active participants and often want a role in the design of the process in generating options. I think what we're starting to recognise is that parties actually do want to be part of the decision-making. This is their conflict, this is their story, and they want to feel a sense of connection to that agreement. It makes it real when they leave the mediation room. And I think there's certainly reports coming out in Australia from people's experiences of the justice system, perhaps that they're going through quite a formal tick box mediation process, and they're coming out of it feeling just as disillusioned as if they went through the court process. So there's a disconnect between this agreement we reached, but we didn't really feel like we were part of it. So they were feeling dissatisfied with an agreement. So I think that as a profession, we're going to have to increasingly navigate this nuance of how do we enable people to feel empowered in a dispute resolution process. But how do we do it in a way that doesn't undermine the standards and quality assurance that is required to provide protection for parties in this space? So how do we bridge this space? I talk about the need to combine empathy and quality standards, because what I know in the work that I do, part of my process negotiation is recognising, hey, these are the foundations as a practitioner that I can't shift on. These are my non-negotiables within my national mediation standards. So these are the things that give me authority to hold this space. And I'm really clear about those non-negotiables. But I also say, but I do know there's a whole pile of space where we can negotiate in a way that makes this real for you too. And that's where we bring empathy into the conversation. So by combining this quality standards and empathy, I think it empowers both us as patients and the parties themselves to feel like they can engage in process and contribute to good decisions. I've lost my little mouse. There we go. So cross-cultural impacts in Australia. Some of the ways that I see culture impacting the practice of mediation in Australia includes how culture can impact the process design element. Certainly, International Mediation Institute, their cultural framework talks about how practitioners adjust the mediation process for a cross-cultural environment. Now, this photo down here that you can see is a photo of two Australian Federal Police officers and Jungai in Arnhem Land. So that's Northern Australia. Jungai is a word like a manager who has authority and responsibility for land and ceremony. And in the background behind them are the elders, who are the owners of the ceremony and land. Now, all of these people had come together for what is called the Mawal Rom ceremony. And this is a process I was lucky enough to engage in over probably 12 years, every year for 12 years, to go out to community and participate in a real ceremony. What it taught me is that it is possible to negotiate ceremony from Western and non-Indigenous spaces. So what we did really was, as non-Indigenous people, negotiated with the Yolngu up there around how we conduct mediation. Now, what it looked like was a combination of morning work where we sat down under the tree and we did what you would probably assume and call traditional Western negotiation. And we sit under the tree and we do that work. And then in the afternoon, we participated in traditional ceremony. Now, this was a huge honour, and I'm so lucky to have had that. And it's taught me about process design and generosity to each other. And so what that did then, because we created a mediation process that harnessed the strengths of both cultural systems, it meant that parties were willing to be vulnerable. It meant that parties were willing to engage in hard conversations and wrestle deeply with the hard issues. And as a consequence, the agreement, the information that came out was much more real, practical, and sustainable. So I learned lots, and I could keep talking, but I'll just tick off some of these other topics. So some of the other cross-cultural impacts on mediation that you need to be alert to is capacity and skills. As a non-Indigenous person from a dominant culture, it's really easy for me to forget that I am blessed with a whole pile of skills, knowledge, and understanding. And when I step into different cultural situations, I need to be alert to where other people are at. My work, a lot of it includes upfront work, so capacity development work, because if I don't help people develop those skills to participate effectively, then I'm actually perpetuating a power imbalance in the mediation process. So for me, I'm very conscious of the skills and the capacities of the participants. I'm conscious of timing and readiness. Often parties will want to negotiate and engage in a mediation process, but it's just not the right time. Sometimes I just say, look, I can see that you want to participate in mediation and that both parties are willing to do that, but I wonder if it's not the right time right now. And in saying that, it gives people permission to honour their own needs. Now, I've had people cry by me naming that because it's given them voice and freedom to a challenge that they were really wrestling with. The other issues you have to be aware of, certainly in an Australian context, but I've seen this also in the Pacific, is those challenges around systems of law, traditional law and Western law. And how do you bring those spaces together so that an agreement can be reached that has legitimacy and that it has authority? Because when people leave that space, it needs to be useful. So again, bringing into that cultural lens of practitioners, understanding authority, understanding legitimacy, really examining mindset. How do people approach conflict usually? Well, you know, what do you usually do when things go wrong? How would you like to deal with this? And how do you feel about being in this room to try and resolve this issue? There's a lot of unpacking that we do to help move people out of that threat, flee, freeze, or fight response, that survival instinct. We, as mediators, are helping to shift them out of that into a calmer, more managed space. And that space has to feel familiar to them. So by us having these conversations, we are helping them to prepare for effective negotiation. I've just got a little diagram here that I think kind of, from my perspective in Australia, captures some of this complexity. I bring to the profession my knowledge, my experience, my authorities as a Western-based mediator. And I have to work in a cross-cultural space. Now, in Indigenous communities, that's not my culture. I certainly don't profess to have any authority or expert knowledge in that space. But the conflict we're dealing with is in between. So we all have to work together to try to find a way that enables us to help parties resolve their conflict in this space. I'll often work with a cross-cultural counterpart. It enables me to deal with gender issues. It enables me to recognize that I'm not an expert in that particular culture space, but I am pretty good at bridging that gap. So my cultural counterpart and I bring these spaces together. I've just left a few photos in here because I think it gives you a taste of some of the richness of what is possible in mediation. Again, these are photos that I'm lucky enough to share with you, and they show some of the work in remote Arnhem Land about people coming together to try and resolve complex cross-cultural issues. It is about, so much of it is about process design and capacity. And I think this starts to bring this notion of culture and mediation together. Because we are dealing with people, not textbooks, not legal interpretations, and certainly not money. They're all part of the story, but what drives the conflict is people. So we need to be able to make sure our processes make this mediation space appropriate. We need to help the parties have the skills to participate in this, because I don't know about you guys, but I'm really passionate about helping to create a world where conflict doesn't divide us anymore. And that means we need people with the skills, not just us, but the people in conflict themselves. We need them to be able to walk away from these mediations feeling like, hey, I've learned something and I can apply it. So here's a couple of quick tips for you in the cross-cultural space. I would encourage you to talk about roles and responsibilities, flesh out a conflict assessment, capacity and design, work with the parties around that. Be curious, bring curiosity, not just to the questions you ask in mediation, but to the process design, and negotiate a legitimacy for meaningful outcomes. Because if parties feel like they've been engaged, it's more likely their agreement will be sustainable. I have 5 more minutes to go. I was going to go through these questions. What I think I'll do, Vikram, is provide you with this PowerPoint slide, and that can be shared out if it needs to be. But I'd really like to, I guess, open up some space for some questions. And if there are no questions, I'll go back to my questions. So thank you for listening to me. Again, I'm so excited as a profession that we are having this conversation, and I can't wait to see where it excels us and our whole world into the future. Thank you.
Thank you very much, Sarah. Excellent presentation, which was expected. So, but if you want, you can go through these questions of yours. We can ask Yemi, who's going to come after you, if we can take some time. I had to get your session into it because basically it'll be him telling us. So when he comes in, we'll ask him, not a problem. So you want to go through these questions? Not a problem. Then after that, I'll get to my questions.
All right. So one of the questions was, how do you explore the assumptions of culture and translate this into practice through the negotiation of process? And I think I've kind of addressed that as we go. But I think what I see as a challenge for us as a profession is starting to recognize those assumptions, bringing a consciousness to what we do. How do we help clients articulate value? Again, I think that as a profession, we haven't been particularly good at helping clients understand the value of mediation. We haven't been particularly good at really listening to not just their conflict, but what do you actually need to move forward? So I'm really curious about how we start to articulate value differently. And I think the challenge has been in part because our profession has so strongly been driven by lawyers who bring quite a particular frame of reference. There's an assumed, well, you just know the value, so you just must know the value of mediation. And I think we have to get better at telling the story to the ordinary person, helping make it meaningful. This really is about this next question, bringing people into the room. As practitioners, I think sometimes we need to put our egos aside and be willing to not get drawn into the conflict itself, because there are specific boundaries we don't cross, but we can bring ourselves into the negotiation of process with a focus on empowering the decision making. So people won't be vulnerable if we have humanity to the room. And it is a challenge around how we align access to justice, resolution, and peacemaking for the broader community. And this is an issue that isn't going away, because accessing the justice system, certainly in the Western context, is getting more and more expensive. So there's this divide opening up. And the process of resolution and how do we bring our differences together, it sometimes seems that it's getting worse and harder. So the world needs peacemakers and mediators more than ever. Thank you.
Perfect. Thank you. But Sarah, the one worry, well, the questions will come later. The first worry is you said that mediators in Australia cannot practice only as mediators. That's a very, very worrying aspect with so many years of experience in mediation, which countries are like ours are just getting there. Why is that happening and how do we change that?
I think it's happening, well, there's a competition, right, that's happening between particularly the lawyers that have owned the dispute resolution space, and then their reluctance to let others in to do mediation. They see it as a threat, not everyone, but many see it as a threat to their income. So mediation or mediators become direct competition to them. And from my perspective, I think that that's not actually the case, and that we need really good lawyers who understand mediation, and we need really good mediators that know how to allow the lawyers to come into the process as well. So it's not a finite yes, no, black and white environment. We need to shift our thinking and say that there is room for everybody.
Because I just feel maybe we have to be looking at lawyers, their role, maybe a little too much. Maybe we'll have to then spread that awareness and the need for it within the people, because you said access to justice. You're saying access to justice in a country like ours, we are denied justice because justice delayed is justice denied. And
that's right.
14, 20 years in a court cannot be justice. I mean, whatever way you look at it.
Absolutely
so that is an issue. Yeah. But when you talk about the Asian model of mediation, the indigenous community model, can we look at, is there a indigenous community model also that you can look at?
Well, certainly in Australia, it's more complex because there are over 100 different language groups in Australia. So many communities, there will be many different models for many communities. And some of those communities have lost cultural knowledge themselves. So they have lost that knowledge of how they traditionally resolve disputes. So it's a complex task. But often for those communities whose culture and law is still strong, they will have very specific laws and processes around how they traditionally resolved conflict. And it will include a degree of punishment, but it also always included a degree of healing. So it wasn't just punishment, but it was healing built into that model. I think that the Western model probably misses that healing element. We reach resolution, but we miss that healing element. And so there's this ongoing wound that weeps. So I couldn't give you one example, but it will often, most communities where culture is strong, it will include gender separate sessions and group sessions. So you do both and one the same. Some of it will be men's business, some of it will be women's business. Some of it will be particular ceremonies depending on who's involved in the conflict.
Because Sarah, whenever I hear a lot about indigenous communities and mediation, largely the discussion normally goes towards restorative practices, restorative justice practices, and a lot of on the mediation as such for other disputes. I don't hear too much on that. I mean, is that how it is?
Look, I think that the language of restorative justice has got a lot of traction. And it's certainly attractive and seems like, oh, look, we can just roll this out as being traditional. I think it's more complex than that. It might work in some communities. New Zealand's doing some amazing things around restorative justice, and so some pockets in Australia. But restorative justice isn't necessarily a dispute resolution process. Sometimes that is about the how do we heal and fix up from the drama or from the conflict or from the perpetration of some violence. So I think it's about recognising restorative justice place in the scheme and recognising that there isn't one size fits all.
Yeah, because that is what I'm saying, because I haven't heard too much on the discussion on the actual mediation.
Yeah.
And are there actually some things that you have seen the way they go about the mediation process?
Yeah, look, I'm one of the, I guess I would probably say I'm one of the few that have had the privilege of working and understanding it. Some of this knowledge I can't share with you because it's privileged information. So only those that have gone through can share it. I can say that that I know that there are very specific examples, and probably I can send some links to you. There's a couple of links on Mile Rome, which gives you a taste of what that might look like. There's a growing recognition because of native title in Australia that the negotiation process has to engage in traditional decision-making processes. So you'll see in that space more acknowledgement of working with elders, working with particular clan groups around who makes decisions around what.
Because a lot of times when we talk about Indigenous communities or the whole concept of traditional mediation, we end up seeing that finally it wasn't really mediation, but it was to a certain extent arbitration, or the person had the authority in that sense. But that's why the definition of Singapore Convention does not have the authority to impose the decision. So do you see that there?
Certainly in some pockets, in some traditional communities, the mediator has more of a determinative role, not just mediator. There is a mediation there, but they are also bringing their authority and status as an elder to contribute to the peacemaking process. I think that can be difficult for some Westerners to wrap their heads around. And I think that that's a really important aspect to recognise and say this is a valid way of this community resolving their disputes. And so as Western practitioners, we have to check our own bias in this as well. And I think that's important.
Yeah, no, definitely. But I just feel that maybe when we say pure mediation, this whole made up kinds of discussion, maybe we've seen that already. But I loved your heartbeat but that aspect was very, very, very interesting.
Thank you.
But in terms of, the one question that Giovanni has is that being a second generation lawyer, how do you see, or when you discuss with your father, mediation did he see it in his time, or has he seen a change in that?
Yeah, look, I think that, I'm so privileged to be able to debrief with my father all the time. So I have inbuilt supervision and debrief, and we often do that. And I've worked with him. And I think that's a wonderful thing. I think sometimes he's become a little bit disillusioned with the profession and where its potential was and where we have come. I think that I don't want to speak for him, but I certainly see there's a growing frustration with him around how mediation seems to be not empowering parties so much anymore. And for him, as quite a social justice advocate, it really was about how do we bring people and help people participate in decision making.
But do you have some solutions maybe or thoughts on that?
I think, look, I don't know whether I have solutions, but I do think it's conversations we need to be having and recognising these dynamics. I don't think it's a one way or the other way. I think we as mediators need to be better at managing that rhythm and that movement, that it can be many things, but what are our underlying principles? So that's where we get clear about those underlying principles and how we
about the Indigenous communities and how they go about the process. Maybe we have lots to learn from there, and maybe we can start looking at that. Maybe we've gone wrong somewhere.
I feel very privileged to have learnt so much about my own practice from my experiences. But I would also say that the communities that I've worked with over a long period of time have learnt just as much from me. And I think this is this thing around mutual respect, is that it's only in working together that we will get the answers, and making space for each other. And isn't that rich? Isn't that beautiful, beautiful blooming that happens when we can all draw on all of our strengths and learn from each other?
Because of course, within the communities, you don't want to talk too much about it because it's maybe confidential and privileged. But what about with the communities, when you're actually mediating, where there are maybe the mining issues or whatever, those issues come up, when you mediate with them, how does that work? What have you seen in terms of that mediation?
Where do I even start? Such a big question. Look, I think that, my work always begins with my intake and assessment around who are the parties involved, what is the context we're operating in, what does it mean to make good decisions in with you, the party, and with the other party, and how might we manage that together? So then the process design starts from the get-go, and that's before I've even asked the question, so tell me about this conflict, what's been going on and what's it about? And then we have that conversation. And then we have the conversation around what is it that you want out of this situation? Because so often they have become caught up in itself that they haven't stopped to think about what it means to resolve this conflict. So we have to do work around unpacking that as well. And that's true for commercial mining cases as it is for boardrooms. And I think that it's this clarity that we can create in that preparation stage that helps make a mediation itself become more effective. It helps us get better results. The success rate increases rapidly when you do all that preparation work.
Because when you're mediating with the communities, I mean, I don't know, who are the parties? Who are the parties there?
It can be state government, federal government, mining companies, not-for-profits, community organisation boards, different clan groups. It can be different family groups. You know, that's just the start of the mix, I guess.
No, but I'm just thinking, is it an informal process? It is conducted in an informal way?
Look, it depends. It depends on the cases that I'm doing. I do both formal work, and sometimes when it's particularly just within the community itself, the process tends to be less formal, because what are the community? They need to resolve the conflict in a way that can let them get on with living their lives. So a commercial agreement in a mediation, a commercial structured mediation isn't going to mean anything to them in a community aspect. So we adjust and make it more formal and meaningful for them. And that might mean lots of little small group meetings before we bring everyone together, because I'm not going to bring them all together until I know that I can manage the risk of this escalating. So we might do it family groups. We might then build it up to a couple of family groups, and then it might bring up everyone together. So we're layering the process.
Well, I'm just thinking in a situation where you are, I don't know about what comes up. Maybe mining is one thing which comes to mind, and But when you have a police, is it a police officer in uniform sitting there? Does that affect the community, the indigenous community reacting to that mediation? Yep. How do you look at that?
Yeah, look, all of those things can play a role in it. I know that I did a mediation once that got referred to, it was a whole of community mediation referred from the Supreme Court in Northern Territory, and it related to an issue that was going through the courts that had resulted in community violence. And so the judge had delegated me out to see if mediation could help deal with the community violence problem, not the court case, but of course they're interrelated. And so police were out there in their uniforms, lawyers were out there, and the whole of community were out there. So we had to manage how the experience for the community members were of those police officers in their cars and their uniform. It can be intimidating, right? And it can influence the community's willingness to have hard conversations. So all of these things have to be managed and negotiated as early as possible, and also having risk management plans in case it goes wrong. So if I started to feel like the police presence was creating blockages to the process, then my responsibility is to talk with them and say, hey, look, this is happening right now. Do you reckon you guys could go off and grab a drink at the deli, and maybe I'll give you a buzz when I want you to come back again? So my job is to manage all those.
Yeah, because I'm asking you so many questions on that because you are one person who's going to tell us a lot about that. Because of course, mediation.
We should do another talk.
No, this is important. No, because I'm just thinking, does the community, indigenous community understand what mediation is, what they're doing, or is it something that, because like I said, traditionally, if this whole concept of it being kind of arbitration, do they now, when they're into that discussion, do they know where it's going?
Yeah, look, I think mediation, the word mediation, has been around long enough that most communities will know of the word mediation. It doesn't mean they know what it means in real life and practice, because, well, like Shifat, like you were saying, their experiences of mediation could have been really bad. So you've got people going out to do cross-cultural mediation work that really don't know what they're doing. And so people become disillusioned by it. You've got people that know of mediation but don't think it would work in their communities because they think it's something that happens in Perth City in a boardroom. And so already they're offside. So when you work in the cross-cultural environment, you have to unpack all of that before you start the mediation process itself.
Okay, so basically Reza had some questions for you. I'm asking him to ask you those questions.
Okay.
Thank you very much, Mrs. Blake, for your great presentation. I've got a couple of questions. The first question is that you talked about the cross-cultural issues and the disputes that rise from those situations. And as far as you're a strategist, I figured out that we have to locate where the position of the parties are and how to find a route in the map to bring them into a settlement. How in the world are we going to make mediators who have a rich understanding of all different cultures around the world? How is that feasible to make people understand different cultures?
Great question. I don't think it is possible. But what we can do is develop in mediators the capacity to build bridges. We don't have to have all the answers, but we can develop a cultural capacity to build bridges and at least bring, for instance, a set of questions. Hey, I'm working in a cross-cultural space. So issue number one, are you working in a cross-cultural space, or is this conflict in a cross-cultural space? If it is yes, then what are some questions you need to consider? If you go to the IMI framework, they've got some really great cultural questions that you can start to ask your clients that you're working with. How might this impact your decision making? How do you usually make decision making? Are there any things that I need to be aware of that may impact this mediation process? You might also think, as a mediator, it might be important for you to find a cultural counterpart. You don't have to have a co-mediator, but it might be an advisor that's helping you understand the cultural nuances that you're working within. Much like we're becoming used to working with translators, for instance, it might be that we can work with cultural counterparts that are advising us on those cultural issues.
Thank you very much. And the second question comes from an oil and gas student background. Well, as far as I know, in Australia, Indigenous people, states and federal government, and even the Crown Estate have ownership rights and operational rights on mineral resources. The first question is, how does Crown Estate function in the Australian structure? And the second one is how mediation plays a role in the disputes that rise from this situation.
The first part of the question, I would refer them to the Australian government website, because not being a non-lawyer, I'm going to stuff it up if I give you the answer around that. But what I can say is that in Australia, we have federal government and state government, just separations of power, and that land is allocated privately, federally, or state-based, and that impacts ownership rights. In Australia, the Indigenous people, particularly here, we have the native title legislation, which is a specific framework that guides how people negotiate land ownership. And so second part of that question really is that this framework is very particular about what a native title mediation negotiation looks like and what you have to do. Unfortunately, well, they build into it the notion for recognizing traditional decision-making processes, but because the context of native title land issues is so big, it can result in an agreement being reached around who has ownership rights of this particular piece of land, but the conflicts don't go away because it's created inter-community conflicts between family groups that are now in competition with each other about accessing the products of that agreement. So money, decision-making rights, commercial entities. So it's a very complex space.
Thank you. And the last question is that how do you see the mediation is going to play a more effective role in the future of Australian legal system in contract with Commonwealth countries and the rest of the world?
I think that from the Singapore Convention perspective, particularly, Australia hasn't signed up to it at this stage. But I think that perhaps it's a matter of time and that we probably will. I think that we haven't done it to date because we have it's so much already part of our judicial framework. So I think that there wasn't this need to feel like we had to establish it. I think that certainly the connections around international mediation is that it's becoming very normalized, particularly for commercial cases. And people recognize that to resolve commercial conflict requires mediation playing some role in that.
Thank you very much. Thank you for your time.
Thank you.
Sir, I think maybe you can also get Shifat in because we had to rush her presentation because obviously we had to start yours on time. I mean, but
I'll put myself on mute, but thank you. Thanks for the questions.
If you want to ask her something, you can also ask her something. But Shifat, you had to just rush your presentation up. Is there anything else that you wanted to add? Please do so.
I don't currently have anything to add, actually.
Okay. So because I mean, of course, you covered everything, so that's not a problem. But again, in terms of private mediation, how is private mediation developing in Bangladesh?
Private mediation is not much developing. Which is developing is the NGO-based mediation is developing in Bangladesh currently, and there is a nice initiative by the Madaripur Mediation NGO, and it is actually serving much to the poor people and those people who cannot afford justice to the court.
So basically, when you say NGOs, you're talking about community mediation. It's like community mediation,
yes,
or
yeah, they are actually serving community-based mediation.
But in terms of law relating to private mediation, I mean, what is the situation in the law?
Different laws have, this is not for private mediation, I guess. This is like law adopted mediation, and there are some institutional mediation as well. Like Bangladesh International Arbitration Center has their own rule of mediation, and they provide training and they conduct mediation from their side.
Yeah, because that's their own setup. But in terms of the law in Bangladesh, there's nothing to regulate private mediation. I mean, the sense of enforceability or confidentiality protection and all that.
Not in my knowledge, no. I don't think so.
Because I mean, I am looking at it from the perspective that there is so much of case, whatever. I'm sure there are lots of cases pending in courts. So in that sense, are people considering private mediation at all? I mean, is there any development at all there?
Actually, the development is progress. I mean, what would I say? This is actually a sector in which Bangladesh is progressing currently, but most of the people do not know about the mediation process. And in terms of ADR, people are more inclined to the arbitration sector currently. So mediation is actually newly being promoted, but the NGO-based promotion mediation is comparatively relatively old, like several years. That's it, and nothing much about this. And we're just taking trainings from different international institutions, so that we can make it better and to like adhere to the actual process of mediation.
Well, I mean, I'll put a question to you, but Sarah, this question will also go to you. Do you think that the court-related mediation, which of course, I'm sure there is a lot happening there, is that really serving its purpose to promote mediation, or is it in whatever way finishing off the profession, where because people are getting it almost free? I don't know whether how much they're paying for it there, but most places they're not really paying much to it, and it's also connected to litigation in some way in their mind. Is that affecting the culture of mediation? Is there anything on that? Maybe it's too early. Maybe it's too early for Bangladesh to be getting there.
Yeah,
But maybe Sarah will be able to, because they've been obviously been doing it for that many years. So Sarah, how do you look at this?
It's interesting to from a community mediation perspective, how access to free mediation has influenced our broader industry over here. I think that there's a degree of when a mediation service is new, and people aren't familiar with it, by making it free and accessible, it opens up a gap for education that you wouldn't have had beforehand. So I think that that's a really useful thing. But as a profession grows, I do think there's this tension around the need to pay mediators, for instance, for their work, and this assumption that mediators will do it for free. So certainly here in Australia, there is tension around that. And mediators have been asked to do complex work without getting compensated appropriately, while there's government parties on the other side getting paid because they're employment roles. And is that really fair that you're not paying the mediators? So I think that as a profession, we need to be more confident in recognizing that mediators should be compensated for this work, but it might be a thing that takes time. So we might not be able to do it now, but let's talk about it so that we can put steps in place for a longer term.
Because the way I'm looking at it from my own experience here, there is, of course, lots of work, and parties are willing to pay mediators. Private mediation, I'm only talking about private mediation, and of course I am developing it with the commercial sector, and they are willing to pay. Now if they're willing to pay and there is a demand, I'm just trying to learn from jurisdictions where, of course, it's a much more mature market. Where have we gone wrong there? Because I'm looking from the US experience. I mean, you talk about mediation 40 years and everything, and at the other end, the number of cases which are filed in court. Now the problem is a Google search gives me two figures: 100 million and also 40 million. So I don't know what is correct for the US, but it's a population of only about 300 million. So if it's only 40 million also, it's compared to population almost 10 to 12% of the population. If that happens in India, it's about 180 million cases will go into court every year, which obviously right now 18 million go. So either are we getting something right? Traditionally, maybe because we're a large rural population, could that be one aspect of it? So I mean, I'm just trying to see that where are we going to be able to, are we going to learn from that and not make the same mistakes, because that model is pushed in a lot of countries. Yeah. But is that, oh yeah, please.
I like, I think that culture aspect could be playing a role in it. I think that one of the traps we have fallen into in Australia is assuming that a good mediator has to be a judge. And so that restricted the access to a mediator, not because others weren't good, but there was a narrative out there that this is what a good mediator looks like. And so that's why it made it difficult for most other people coming into the profession to get work. So you're competing with that status. So I think it's about recognizing that, what is a good mediator? How do you make sure lots of people can access those mediators? And that's a story, certainly in Australia and the US, it's around us as mediation professionals, having a better marketing strategy, I think. And I think the challenge has been that the narrative in our country and the US has been driven by lawyers who aren't necessarily good at communicating, engaging in a marketing sense around the benefits of mediation.
Because my interest has always been that we have to develop a culture of mediation at the grassroots, and that would take it forward. because the way it's been pushed down through the court system, I don't think it's really working properly.
Yeah.
Like I said, if in the US it hasn't worked in so many years, and if people are still going to court, so there's a fundamental issue. I feel it's there. But the way I've gone about it is to give people a flavor of mediation. I tell them, you don't have to fix any fee with me. You pay on value received, and that works perfectly. So that's worked well. So you have to leave now.
Yes, I can
because
I have to pick up my kids.
Yeah, perfect. And lots
Thank
of
you, everyone.
with that part of it, I wanted to discuss with you how your kids are taking to mediation, but another time.
Their generation, I'm hoping.